Another very interesting hearing today in the Karen Reed case. And unfortunately, I was not able to live stream it for you and give you my real-time analysis because I was on a plane. But as soon as that plane landed, I made a beeline for the office, watched the hearing, took some notes, and now I'm going to share with you my thoughts and my analysis on what happened today in court. I think what's at the forefront of everyone's mind today is the oral motion that was made by Alan Jackson at the conclusion of the hearing, which was a motion to continue the trial, which means he does not want the trial to start April 1st anymore. He wants it to get adjourned. So we're going to talk about that at the end of the video because, after all, it did happen at the end of the day today. So let's start from the beginning. And as we've come to expect at these hearings with Karen Reed, these hearings seem to always start off with some fireworks. And the reason for that is that we've all kind of been waiting to see what Judge Cannoni does about this overarching issue that we've been sitting on for the past couple of weeks about whether there was misrepresentations that were made by defense counsel at sidebar and open court and some pleadings regarding the relationship they had with the ARCA experts, whether they turned over all the discovery, including the invoice that was paid. So those type of things, that's what we're all waiting to hear what she does, because if she decides that she's going to revoke Alan Jackson's pro hoc vice, well, then that's going to obviously throw a very big curveball into this whole defense. And my guess on this for the past couple of weeks was that the closer that this gets to trial, the less likely it is that she's going to throw him off the case, because the immediate thing that you would do if you have your lead counsel, which, even though he said he's not really lead, but he's probably technically lead counsel in this case, if he's thrown off the case, he's definitely a very important part of this case, then you're going to immediately ask the judge to continue the trial, because you need to get a new attorney in there, or at least whichever attorneys are left, they have to take over all of the work that he was doing. So the first thing that you would do is move to adjourn the trial. And if that's not granted, then you can argue that you're not effective assistance of counsel anymore, and it can be an appealable issue. So the closer that this was getting to trial, the more that I was thinking that she's not going to revoke his pro hoc vice admittance into Massachusetts. And after all, that is exactly what she did. So she started off with the hearing with these findings on the record that, number one, she found that these misrepresentations were, number one, material, which is obviously a very important part, that it's material misrepresentations. It wasn't just some collateral issue that they made a misrepresentation about. It's a material misrepresentation. Number two is that it was repeated. It was repeated misrepresentation. It wasn't just one. It was a number of times. And number three, that it was deliberate, meaning deliberate, it was intentional, it wasn't mistaken. And so therefore, these are all things that weigh in the favor that she's going to sanction the defense team or Alan Jackson, whoever she finds committed these material misrepresentations and did not act with the appropriate candor to the tribunal. But what she first did was she said, we're going to have a sidebar, just Karen Reed and the defense team. So she had that sidebar without the prosecution there. And what seemed to have gone on with the sidebar was that she asked Karen Reed, do you really want Alan Jackson on the case? And of course she said, of course I want him on the case. He's one of the best trial lawyers in America. So of course she's going to want him on the case. And so then she sent them back to the counsel table and she said, well, I am not going to revoke Alan Jackson's pro hoc vice, and I am not going to exclude the ARCA experts from testifying. Now I thought right away that none of these misrepresentations should mean that the ARCA experts get excluded. So that obviously I think was going to be the right decision there. The only question in my mind was what she's going to do with Alan Jackson and what type of sanction she's going to impose on the defense team or Alan Jackson or wherever she found that misrepresented these things to the court. Well, she did not exclude the ARCA experts, and she did not, at least today, sanction the defense. So a very, very big win for Karen Reed. No sanction at all. You would think that as soon as she has these findings on the record, there's going to be some sort of sanction, but no sanction. So a very big win for Karen Reed's defense team. Maybe she'll come up with a sanction later, but that's what happened today. So moving on to the next motions in limine. So there is a motion to exclude Dr. Wolf. Now, Dr. Wolf is the Commonwealth's neurosurgeon who they want to call to talk about how John O'Keefe died. And one of his very important conclusions and opinions is that John O'Keefe could not have died from a punch or from being banged in the back of his head with a baseball bat or any sort of blunt object. The only way that this could have happened is if he fell backwards. That's one of his very important conclusions that he's going to testify about when he gets called in the Commonwealth's case in chief. So this was Robert Alessi arguing that this expert, Dr. Wolf, cannot testify about certain things. Now, we kind of broke down that motion specifically. We spoke about the differences between mechanism and causation. It's really, really grasping at straws if you want to say that there's a difference between mechanism of injury and causation of injury. And really what Robert Alessi was really more focused on with his argument was two things. Number one is that he can't testify about the manner of death. Manner of death is only or should only be left to a medical examiner, forensic pathologist. That's what a medical examiner has the expertise to do. A neurosurgeon definitely treats injuries to the head. Maybe he can talk about causation. He kind of stipulated to that okay, for the sake of the argument, I'll stipulate that he could talk about causation of these injuries the same way, for example, Dr. Russell is going to talk about the causation of the injuries to John O'Keefe's arm. So technically that he was kind of giving up on that argument. But in terms of manner of death, he should not be able to testify about, and he's just simply not out of his expertise to testify about that. Now, also, something that he argued about is that this idea of frozen ground, that when you have frozen ground and determining how hard the ground is, so that when somebody falls backward on that frozen ground, it can cause this type of injury, that this Dr. Wolf cannot testify about either. And this is a point that I made also when we were talking about this in the last motion, because this is a very important part. A neurosurgeon or neurologist can talk about causation, but he can't talk about how hard the ground is. How is he supposed to know how hard frozen ground is? That's definitely out of his expertise. There's specific experts that can talk about the freeze and thaw cycles and things like that. We spoke about this when it had to do with the meteorologist that the Commonwealth wants to offer to testify about the hardness of the ground when it was frozen. So this is actually a good point that Robert Alessi made. So number one, the manner of death, really, he was arguing that he should not be able to testify. Maybe he can talk about the causation. Okay, that's number one. But in terms of how hard the ground is when it's frozen, that really should be completely off limits for him as well. And it didn't seem like Hank Brennan really responded to that part of the argument about how hard the frozen ground is. So exactly what his position on that is, it wasn't very clear from his oral argument today, although he did argue that, of course, he could talk about causation. He didn't really address so much the manner of how he can talk about the manner of this manner of death. So that part he didn't really address either. It was really more about the causation, which really Robert Alessi was kind of stipulating to already. So maybe Judge Cannoni will rule on this, that, okay, he could talk about causation, but not manner of death. Maybe that, and maybe she's going to order that he cannot talk about how hard the ground was, because of the freeze and thaw cycles. So we'll see what happens. Of course, she did take this under advisement like she does with a lot of these motions. Moving on, they argue the Hanley demonstrative exhibit. And this was the motion that the defense should be able to show a demonstrative exhibit. Now, there's really two parts to this that you really have to understand. One is a demonstrative exhibit, just to be able to use a demonstrative exhibit. Generally speaking, a demonstrative exhibit is not admissible. You're just using it to kind of help the witness testify and to make it clear to the jury what the witness is testifying about. So if you had to ask the question, what is the evidence that the jury is able to rely on if you use a demonstrative? They're not allowed to use the demonstrative exhibit to rely on as evidence, but they could use the exhibit to help them visualize what the expert is testifying about. So that's in terms of just using a chalk or using some sort of demonstrative exhibit to show which pieces of glass were associated with what, and what had an unknown source, what didn't have an unknown source, which piece of glass had which source. So that was something that, number one, they argued that they should be able to use a demonstrative exhibit. Number two is that Alan Jackson also argued for that they should be able to admit this demonstrative as an exhibit. Now that's where it gets a little bit more complicated, because if you want to admit this exhibit, so that you have to, number one, you have to lay a foundation, you have to authenticate it, and one of the Hank Brennan's arguments back about this, which was, I think, a good argument, was the fact that we know that Hanley's report, an expert report, is not admissible. So if the report is not admissible, how can you kind of backdoor your way in to get some sort of exhibit admitted when her own report is not admissible? So now you want this to be admissible. So that's his issue with Alan Jackson's argument that they should be able to even admit this as an exhibit. So again, when you're admitting it as an exhibit, it means that this is evidence now. The exhibit is evidence. It's something that the jury can take back with them in the jury deliberation room. So that's his issue on that. I don't think Alan Jackson's going to get that. He's not going to get this demonstrative exhibit to be able to be admitted as an exhibit. Now maybe he'll try, but that's going to be an issue that they're probably going to take up closer to trial. But then the question is, what about using it as a demonstrative? So Hank Brennan initially said, he doesn't really mind using demonstrative exhibits, but the issue with this specific demonstrative exhibit that they want to use is that it has certain names on it, like Trooper Proctor, and it has some other classifications or writings on it that he doesn't necessarily agree with, and it doesn't give a full picture. So you can't just use a demonstrative exhibit about a few items and then not really give the whole picture. So that's what he had some issues with that. And he said maybe this is something that they can work out together, Hank Brennan and the defense attorneys, what exactly will classify as a authentic demonstrative exhibit to be able to use to be able to help the jury understand this expert Hanley's testimony. So that was in terms of that. Now, something that he also mentioned, Hank Brennan, is that another reason why he wants to kind of pause and think about this specific motion is that last night, or a couple nights ago, whenever it was, there was a documentary that just came out again with Karen Reed. And in that documentary, Karen Reed said the following. She said that John O'Keefe actually took her vodka soda glass out of the car. So it was actually him taking her glass out of the car. And that she testified, or she didn't testify, but she said this in the documentary, that she pulled glass out of John O'Keefe's face or around his face. So these are things that he said they were not aware of before. This is the first time they're hearing her statements about it. So they want to kind of just think this through before they just agree to these demonstrative exhibits. So that's just another point that interesting that came out today in the trial. Judge Cannoni took it under advisement, and she also encouraged the parties to work together to see whether they're able to kind of agree on some sort of demonstrative exhibit. Okay, moving on. There's a motion in limine regarding the Aruba incident. And we know the Marietta Sullivan and the Laura Sullivan incident in Aruba, and the allegations that Karen Reed thought that she saw John O'Keefe kissing this other girl, and then she got mad and she said certain things, and there was some testimony about what the relationship was like at that point. But what was interesting that came out was that Hank Brennan said that he has no intention of introducing the Aruba incident at all, which means he does not intend on calling Marietta Sullivan or Laura Sullivan. So that's just a nice heads up to the defense that he does not plan on calling them at all. Again, he's not foreclosing the idea. If in case it's necessary for whatever reason, maybe in the defense's case, then maybe he'll feel that it is necessary to bring them in, but he is not planning on talking about the Aruba incident at all. So that's something interesting that we learned today in the case. There's also a motion in limine regarding the view. And this is interesting because usually, right, the view, just to take a look at 34 Fairview, look where things are, look where the flagpole is, look where the body was located, things like that. So that they were planning on taking the jury to 34 Fairview to look at it. But the question was, number one, whether Karen Reed is able to go along with them to watch, see what they're looking at. That was one question. The other question was where the vehicle is, because they also want her to see they also want the jury to be able to see the vehicle. Now the question is, where should the vehicle be? Should it also be at 34 Fairview? And if it is, where should it be parked at 34 Fairview? Should it be parked in the driveway? Should it be parked on the side of the street? And that was an issue that Hank Brennan had. He says, no, I don't want the vehicle near 34 Fairview. If they want to see the vehicle, then we can take them to a different location to look at the vehicle. And here the defense said, no, we want them to see the vehicle at 34 Fairview so they can kind of envision everything that's going on with this vehicle and the allegations that the Commonwealth are making with this vehicle that she backed it up, and just kind of see the measurements and see things like that. So that is something also we're going to have to see how she rules on regarding that. There was another motion limine that they argued with. This was to sequester the witnesses after they testify. And here the question really was not just after they testify, but the question was, what about the Alberts and the McCabe's who watched the closing arguments? And the argument there was that there was some report by a juror that they felt very intimidated by these steers that they were getting, or they felt that they were getting, or this one juror felt that he or she was getting from either Brian Albert or the McCabe's. And this is something that, again, according to the defense's case, they're third-party culprits, or possible third-party culprits. So, it can be intimidating to the jurors to see them staring at them. And that's something that obviously they do not want. So that was something, and that was, again, something that Judge Cannoni took under advisement. There was also the issue of the ARCA experts and what amounts of money they were paid in order to come and do the voir dire. So you remember that they were called in just to do a voir dire, and that costs money. That's something that Karen Reed had to pay. But should the jury find out about all this money that really, at the request of the Commonwealth, these experts had to come in and fly in and they had to get paid for their time, which Karen Reed paid. So should the jury hear about that, the defense position is that no, that's completely irrelevant. It's okay if you want to introduce the invoice with respect to how much specifically they were paid to testify in this case. Okay, that's one thing. But to all these other charges that Karen Reed had to pay for, which really was not part of their testimony, or was just part of the voir dire because the Commonwealth wanted to go through this Daubert hearing with them, that they should be able to strike those items off of the invoice. So that was something that actually Hank Brennan agreed with, that he will say that he's not going to fight this, and they want to take those charges off of the invoice, that's fine with him. Now, there's a question, the next motion in limine was a question about the voir dire. Now, as we've spoken about a lot on this channel, it's so important to do jury questioning, right? You want to be able, as a juror, as an attorney, you want to be able to talk to the jury, ask them questions, get a feeling for them, have some sort of relationship, see if you connect with any jurors. And it's something that obviously the defense definitely wants to do. So they wanted to have a panel voir dire by the attorneys. Now, it seemed that, again, we're not able to see jury selection, at least, not from Latin, not the rest of us, unless you're actually in the courtroom at the time. But it seemed that last trial, the attorneys were not able to ask the jurors questions. And again, I'm just speculating here a little bit from what I'm trying to learn from this hearing that happened today. So if I'm wrong, please correct me. But it seems that they were not able to ask questions directly to the jurors. And it was actually done by the court. And then there were sidebars, extensive sidebars, where there would be some follow-up questions that Alan Jackson had, or the defense team had, or the Commonwealth had, and then they would ask the judge to then go ask the questions to the jury. And this is something that seems that Judge Cannoni wants to continue, that she does not want the attorneys to actually be able to voir dire the jurors themselves, which again, I think it's hurtful definitely for the defense as well as the prosecution, because you always want to see if you can build some sort of rapport with the jurors as you are asking questions to them. So it seems that she's not going to allow that. There is going to be a questionnaire, but the questionnaire is limited to 1 page, so they got to submit that. And again, she's saying that you can have extensive sidebars and follow-up questions that you want the judge to ask, but it seems that they're not going to be asking questions directly to the jurors. So I was asked once if I would go see the trial, what part of the trial would I like to see? And I said jury selection, because I think to me that's one of the most important parts of of the trial, and something that I can't see otherwise that's live streamed. But at this point, if the lawyers are not even able to ask questions of them, well, then it's not going to be terribly exciting for me to see. So you can give that seat to somebody else. All right, moving on. So there's another motion limit that they spoke about today, and that was whether they can talk to a witness after or in the middle of that witness's testimony. This was an issue that came up last trial when I think it was Brian Albert was on the stand, and then they took a break. And then when they came back for cross-examination after the lunch break, it seems that he did speak to Adam Lally over the lunch break. So this is something that they did not want to happen. They filed a motion about that, and they both agreed with this. So this was something that is not going to be allowed at the next trial. Then they moved on to the motion in limine with respect to whether witnesses can talk about some sort of harassment or intimidation that they felt or they experienced as a result of being labeled third-party culprits or part of this conspiracy or things like that. So you'll remember at last trial, when Jennifer McCabe was on the stand and Alan Jackson was asking her questions, it came out about the harassment that she experienced at the hands of maybe Turtle Boy or some other people, and posting on social media or showing up to games or whatever they were doing to quote unquote intimidate her or harass her because of her involvement in this case. So that actually came out during trial, and that's something that Alan Jackson did not want to come out again. Now it seems that even in last trial, there was an order that this whole witness intimidation is not allowed to come up. But this is where it gets interesting. And that is if you open the door. And this is something that we hear about a lot as attorneys, and something that you always have to think about, because there are certain times when you have motions in limine or motions that are before the court, before the trial, where you're talking about certain issues that you don't want to come out during trial because they're prejudicial or because they're going to confuse the jury. So there are certain things that the judge will make a ruling that, okay, we are going to rule that none of this is admissible. But if one of you opened the door, then, we have to allow the person to explain. So what seemed to happen at last trial, that there was there was an order, there definitely was an order, and the question was whether Alan Jackson opened the door. Now he maintains that he did not open the door. He did not open the door for her to be able to talk about this intimidation or harassment that she suffered. And I think also there was a time when Allison McCabe was on the stand, when she also, I think she broke down and crying and, talking about the harassment that she experienced. But the point was that whether Alan Jackson opened the door. And what he said was, he looked through the transcript and he didn't feel that he opened the door. Judge Cannoni was very strong in the opinion that he did open the door. So this is, a question. They're going a little bit back and forth, a little bit of friction there. But he ultimately, what this motion really came down to was, we need to know explicitly what exactly is considering opening the door. And we know that this can have really grave ramifications, as we've seen in this last trial with Jennifer McCabe and then Allison McCabe. And then we also know from other trials that these things happen. So for example, the Jennifer Crumbly issue, right? There was an issue there in the Jennifer Crumbly trial where she was having an affair with somebody. and there's this person who was testifying on behalf of the state, and the question was whether this was going to come up, and Jennifer Crumbley's attorney seemed to have opened the door, and she explicitly did that because they took a break and they said, and the judge said, you understand what you're doing now? You're opening this door, and then this stuff about her having an affair can come in, and she didn't care, her attorney at least. So that opened the door. We also know that there was with the Alex Murdaugh case, there was a question about opening the door with some of his issues that with I think it was with the hiding money or stealing money from clients, that also that the judge considered whatever the attorney did opened the door. So you got to be very careful with this opening the door. And this is something that Alan Jackson wants to make sure that it's very clear before the trial what is considered opening the door when it comes to hearing about witness intimidation that was done by Turtle Boy, and what that even has to do, or whether Karen Read was involved in that at all. Now, remember, there was a grand jury, something that Alan Jackson brought out, that there was a grand jury, and they had to decide whether they can charge Karen Read with witness intimidation. And that grand jury came back that they cannot. And this is something that Alan Jackson made a big point about, because we all know that to be able to indict someone is very, very easy. Probable cause is a very, very low standard. And that's what he was arguing, that even though it was such a low standard, the grand jury did not find that Karen Read could be charged, even be charged with witness intimidation. So therefore, any sort of mention of witness intimidation should obviously not be allowed in this case. And that was a very strong argument that he made. But again, ultimately, really, it just came down to that Judge Conant was going to say, I'm going to make the same order that I did last trial, which is that we're not going to bring up witness intimidation unless you open the door. And then the question is going to be, okay, what is considered opening the door? So that's when Hank Brennan got up and he very strongly said, all these, they're trying to paint again, and he had very strong words about how they're trying to paint these witnesses, and they're trying to fabricate things, and they're trying to make things worse than they are. And even though they're trying to bash the witnesses, he was very strong about it. And Alan Jackson stood up in response to that, and he said, I think we all need to calm the drama down a little bit here. Okay. I didn't bash anybody. I'm just talking about, practically speaking, what's considered opening the door. I'm not bashing anybody. I don't want this testimony to come in, because quite frankly, it's completely irrelevant and it has nothing to do with Karen Read, because the grand jury even didn't believe that it was strong enough to even charge her with witness intimidation. So that was just a moment where we had Alan Jackson saying we should just all kind of calm the drama down, as if that's going to do anything with this case, because there is, a lot of drama in this case. Okay, I don't think there's any calming that down. All right, moving on. So then we went on to the motion in limine regarding the blood analysis conversion that the hospital did. And this was very interesting, because this was a very important part of the Commonwealth's case to show that Karen Read was drinking at the time, or that she was considered drunk at the time when she was driving the car. And the argument here is that the medical records themselves in the hospital, it's not considered, they don't perform the same tests that a Massachusetts State crime lab would test. They have different ways of testing it, and it's not as reliable, definitely for court. And in fact, there's specific mention in the medical records where it says that there's a disclaimer that these records and this chemistry and these blood alcohol tests that they're doing should not be used in court. So that's the hospital themselves saying that you should not rely on these for court. And nevertheless, you still had the Commonwealth's witnesses relying on largely what the hospital pulled from Karen Read, and then trying to do this conversion analysis where they're walking back a couple of hours to be able to determine what her blood alcohol level was at the time that she was driving the car. So that was another motion limiting that was argued. And then there was about the criminal record. So about Richard Green, it seems like there's some sort of criminal record issue with Richard Green. And if I heard correctly, I think that's what it was. But the judge says, we're not going to allow that criminal record in. And then finally, we come to the motion to continue the trial. So this is a little surprise to everybody. We all know about the federal appeal. We did a number of videos on it. We analyzed it. But the question here is okay, now we have this federal appeal. Now, what's going to happen if we're in the middle of the trial and the appeal, because even though this one judge said that there's no double jeopardy here and that she can be retried on all three charges, we went through that opinion. But now what happens if the next level of the court, the next appellate level court, they decide that no, she should be acquitted of charges 1 and charges 3. And then we're going to be in the middle of a trial. We're going to have to move for a mistrial in the middle of the trial, because obviously if she's only going to be charged with charge 2, and we defended this case as though she's being charged with charge 1, 2, and 3, it's going to change our whole strategy of the trial. So what's going to happen in that case if that happens? So therefore, Alan Jackson was basically asking the judge to just stay everything, push off the trial, and let's wait to see when this opinion is going to come out from the next appellate level of the federal courts. And this is where the question was, okay, well, how soon do you think we're going to get an opinion from this next level of court that they're appealing to in this federal appeal? So what we were able to learn is that the briefing is due very soon. So the briefing is due, but then the question is going to be, when's the oral argument, and ultimately when's the opinion going to come out? Now, from my experience with appellate courts, even if the briefing is done relatively quickly, especially when you're at a higher level court, the oral argument's not going to be scheduled for a little while, and then it sometimes takes even more of a while to get the opinion out. So you can be looking at a few months to get this next opinion out. So that's the question: is, are we going to push off this trial? And then what's going to happen if they want to appeal it to the United States Supreme Court? What's going to happen in that case? And then we're going to have to wait for another year and a half. So what I see happening in this case, I don't think Judge Cannone is going to continue the case because of the appeal. Because of the appeal, I don't think it's going to happen. I think they're going to continue with the trial April 1st. We don't have to consider, she does not require to consider these appeals at the time. This time, definitely. She does not have to consider these appeals and stay the case because pending the appeals and see what happens with those opinions. So she's not required to do it. She wants this trial to go on, and you could be looking at months and months and months and more. And there's a lot of issues with getting the correct amount of jurors to show up for jury selection, because everyone's going to have heard of this case. So there's going to be issues there with jury selection, and it's going to push everything off months and months and months, which I do not see her doing. So I don't think that this motion to continue the trial is going to happen. I think you got to mark your calendars for April 1st. I think that this trial is absolutely happening April 1st, unless something changes that has nothing to do with the appeal. So that is essentially what happened today in a nutshell. That is the recap. And of course, there's still more to argue in this case. There's more motions in limine that were filed, and more motions in general, I think, that were filed that we still have to argue. We still have to get the opinion from Judge Cannone about this motion to dismiss, which I think most people believe is going to get denied. But these are all the loose ends that have to be tied up before the trial begins on April 1st. So the next hearing is going to be Thursday, 9 a.m. And unfortunately, I have an evidentiary hearing scheduled for that day, so I'm most likely not going to be able to live stream the Thursday hearing. But again, hopefully I will be able to catch up on it and do the recap and analysis that you are all going to be waiting for. So that's going to be it for now for this hearing. Keep it here. The trial's coming closer. We're keeping track of all these motions being filed, trying to analyze it all so that you will be in the best position to understand everything that's going on, especially when trial hits. We'll be all ready to really watch this trial in the right way. So that's going to be it for now. If you haven't yet, please subscribe, like, and we will see you next time.